Good morning, and thank you for joining me on the Path to Liberty. It's Wednesday, June 24th, 2020. And on this episode, we're back to talking about the Supreme Court and a phrase that I'm sure we're all pretty much very familiar with. That is legislating from the bench. I'm covering some important articles. This is our anniversary week. We're celebrating our 14th anniversary on Friday. So this week and next, we're going to be highlighting through our email newsletter and on this show some of the most important work that people have done for the 10th Amendment Center over the years. So on this episode, I'm covering articles on the power of the judiciary from Dave Benner, Mike Meharry, Brian McClanahan, and the late, great Raoul Berger. I've got some quotes from founders like Rufus King, Thomas Jefferson, well, that's obvious, and even Chief Justice John Marshall. I hope you guys find this interesting and enjoyable to watch. But first of all, my name is Michael Bolden. We broadcast live every Monday, Wednesday, and Friday at 9:30 a.m. Pacific time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. We've got a bunch of different platforms. We're on both video and audio. Live stream we do at 9:30 a.m. Pacific time on Facebook, YouTube, DLive, Twitch, and Periscope or Twitter. We also have archive video versions at Library, LBRY, library.tv, bitshoot.com, bittube.tv, and brighteon.com. We also have the audio-only podcast editions. You can find those on iTunes, where we're getting a bunch of reviews, well, not tons, but consistently getting new reviews, and that helps us reach new people. It tells Apple to show the podcast to more people. So iTunes, Spotify, Stitcher, Podbean, Google Play, and elsewhere. We actually got an email over the last couple of days inviting us to try out the Podbean live streaming podcast option. I'm going to look at that after Independence Day at some point. And if you guys are really interested in live streaming audio only, let me know. It's kind of like the new version of radio. Anyways, a quick hello in the live chat. And I want to point out that we also do all of these archives, all of the show notes, links to various things that you can read for each episode, all the platforms we're on, and even our membership program where you can support us financially for as little as $2 a month. You can find that all over on the show homepage, 10thamendmentcenter.com/path to liberty, all spelled out again, 10thamendmentcenter.com/path to liberty. Just a quick hello to everyone out in the live chat. I'm very grateful for you spending some time with me today. I couldn't be more appreciative of your support, even just being here with me. Hi to Timothy Martin, Bob Landry. Good to see you guys. Patricia Dance, Melody Skaman, Punky Brewster, Heather Rossi, Tyler, Justin Morrison over on Facebook, Pro-Life, Pro-Liberty on Periscope. I like seeing people comment on Periscope. Thank you. Gerard, MRGF78, SAH Biochemist, my old buddy Andrew Nappy down in Florida. Good to see you, buddy. Punky Brewster, Greg McCauley. I apologize if I got your name wrong. Larry Clark, Dustin Neal, Alexander Helling, and everyone else. Cool. So, of course, thank you so much for being here. Let's dive right into it. We've all heard this phrase, legislating from the bench. And first of all, I should point out that if you haven't seen Monday's show, I covered briefly our annual State of the Nullification Movement report. It's probably the most important one-off document that we publish. This is a 108-page. We've got some of it I've actually run out, but we're getting another print run of these coming that go for some membership renewals. The State of the Nullification Movement report, 108 pages talking about the theory, the philosophy, the strategy of how we work to defeat and undermine and nullify federal programs that violate the Constitution. In other words, almost everything on the books. And then also we talk about how, and we show how it's actually being used in current times to real impact and real concrete effect. So I encourage you to check out that episode from Monday if you have not yet. But let's get right to this. And I want to first start out with this great article from Dave Benner that we published back in 2014. And it really is kind of the inspiration for this entire episode. It's an inspiration for the email that we're going to send out a little bit later today talking about this. The Supreme Court offers opinion, doesn't make law. And that's a huge distinction. So many people refer to, and I actually catch myself doing this from time to time, and I know we've got it on the website incorrectly. We'll talk about Supreme Court opinions as being rulings. And a ruling sounds different than an opinion. Oh, someone tells you, oh, I've ruled on such and such. You take that as kind of like, okay, well, this is how it's going to be. But if the same person tells you, well, here's my opinion on it, well, I think that encourages other people to have their opinion as well. And Dave, in his second paragraph, not the lead, but he says, the power to offer opinion does not equal the power to make law. While today, most people believe that Supreme Court justices carry an aura of infallibility in doing so, that perception was not always the case. In fact, the founders very much were concerned about the political nature of courts. So here from the Philadelphia Convention, this was in June 4th, 1787. I've actually seen it attributed to John Dickinson as well, and I think that's just how the notes on the convention were written. It's possible that it was Dickinson, but I'm almost certain this came from Rufus King in Massachusetts. He says, the judges must interpret the laws. They ought not to be legislators. And this, Rufus was a pretty big government guy of the time. He wasn't like a James Wilson or Hamilton, but he wasn't a Patrick Henry for sure. And he's saying, look, they should not be legislators. This was a concern. And even this guy, John Marshall, in the Osborne case in 1824, he put it this way: courts are the mere instruments of the law and can will nothing. And even though so many people who believe that the court it were really ruled by the court's opinions, that the Constitution means what the Constitution means until the Supreme Court says otherwise, or the Constitution means what the Supreme Court tells us it means only until they change their mind. Even people who cite John Marshall for this type of view, I would say they're actually incorrect. Look at this is what he has to say. It's totally different than how they've applied things today. Courts are the mere instruments of the law and can will nothing. And here from Raoul Berger in the book, I think this was from Government by Judiciary. This is a very important book that you should check out. He cites Nathaniel Gorman, who saw, quote, no advantage of employing the judges in this way. As judges, they are not to be presumed to possess any peculiar knowledge of the mere policy of public measures. They really didn't want the judiciary even involved in the process, giving an opinion about legislation. They just wanted them to deal with law, and that's all. And legislation was left for the legislative branch, and a veto over that was left to the executive branch. Going further, Charles Pinckney also, quote, opposed the interference of the judges in the legislative business. They don't want the founders repeatedly, over and over, from various states. They told us the same thing. They didn't want the courts involved in legislation. Roger Sherman, quote, disapproved of judges meddling in politics and parties. And these are all quotes from the Philadelphia Convention. Berger put it this way. He says, plainly, the framers refused to make the judiciary lawgivers, even to the extent of allowing them to share in the legislative making of law. They actually considered a legislative council, a council where you would actually have the Supreme Court or the federal courts involved. They considered it. Someone wanted it. I believe Elbridge Gerry was one of the lead proponents of this. And they still said, nah, we don't want that. We got to keep them separate. We don't want the courts involved in lawmaking. So he says, even to the extent of allowing them to share in the legislative making of law, not even completely making, they didn't even want them having any part of it whatsoever, let alone finally to decide on policy, an exclusive legislative function, not something as part of the legislature. Here also from Raoul Berger, a great paper called The Supreme Court as a Legislature, a Dissent. He was actually opposing views that were becoming more popular at the time. I think this was probably sometime in the 70s, 1970s, that is, where people were really pushing for the legislature or the judiciary to legislate for equal justice or whatever it may be. Views that people like, they want to get the court in there to force it on everyone. Going further, Berger says, such sentiments were made explicit in John Adams's 1780 Massachusetts Constitution. The same type of view was actually put into the Massachusetts Constitution. And when we understand the federal Constitution, we often look at the state constitutions which preceded it, to understand the philosophical underpinnings of it. And here's how Adams put it in that Constitution, and I believe it's actually part of the Massachusetts Constitution still today. Maybe someone who lives there who's actually read it can tell me one way or the other in the comments. And this is what it says: the judicial shall never exercise the legislative and executive powers, to the end it may be a government of laws and not men. Because if you have an unelected, unaccountable, politically connected set of lawyers that serve for life, and they can make law, then this is a government of men. It's a tyranny, an oligarchy, which we'll get to in a bit. And he says, to Berger again, these sentiments derive from Montesquieu, who was to be the oracle of the several constitutional conventions, and who had written that if judges were to be the legislators, quote, the life and liberty of the subject would be exposed to arbitrary control. And the term arbitrary, it doesn't sound all that menacing to us. Oh, it's an arbitrary thing. But to the founders, when they talked about arbitrary power in the foundations of government or in constitutions, arbitrary means the will of the person exercising the power. They can do whatever they want. And arbitrary power to the founders was a tyranny. That is the definition of a tyranny. There's no limits. As Samuel Adams once put it, he said, in all free states, the Constitution is fixed. It has fixed rules, fixed meanings. I mean, even if it has an amendment process, the way you approach it is fixed. It doesn't just change based on the wills and the opinions and even the meanings of the words, as James Madison once told us, over time. It is fixed in law. Arbitrary control was seen as incredibly dangerous. And this is an article by Brian McClanahan that we published. It was originally from LouRockwell.com, and Brian does such great work. If you haven't checked out his podcast or YouTube show, which is the same show, I encourage you to do that. He's got a lot of really interesting episodes. This is an article after the Affordable Care Act opinion. John Roberts, meet John Marshall. We published it back in 2012, and he starts it out like this. In 1823, Thomas Jefferson, and this was a letter to William Johnson, who was an Associate Justice of the Supreme Court that was nominated by Jefferson, I think in like 1804, and he served like 3 decades on the court. And here's a letter that he sent to him in 1823. He wrote that, quote, this case of Marbury and Madison is continually cited by bench and bar as if it were settled law. As if it were settled law. We still hear it today as if it were settled law. Jefferson was concerned about this, and his nominee to the Supreme Court, William Johnson, didn't disagree in return, as if it were settled law, without any, and I'm going to have a hard time with a couple of these words, animadversion on it being merely an obiter dissertation of the Chief Justice John Marshall. Just kind of translating that without anyone actually saying, oh, you're citing this as settled law, this Marbury versus Madison case. And no one's even challenging this as being just a personal opinion of the Chief Justice. A lot of this stuff in here is just his non-required. It's not relevant to the case at hand, some of the things that Marshall said in that case, according to Jefferson. And McClanahan makes a really good point on this in this article. He says Jefferson was pointing out a fact that Supreme Court decisions are nothing more than the politically motivated constitutional ruminations of politically appointed justices. And you've heard me talk about this a lot recently, and over time, we're always covering Jefferson's warnings, and maybe that's why I'm wearing the Jefferson shirt for this episode, our 10th Amendment Center. You can find that at shop.10thamendmentcenter.com, or if you're on YouTube, we have it posted just below the videos on all of our episodes. Just a quick advertisement there. But Jefferson warned us over and over about allowing a part of the federal government to make final decisions about the power of the federal government. We shouldn't be surprised. Tom Woods pointed this out many times. He spoke for a great event that we did back in 2010 in Fort Worth, Texas. I'm not sure if any of you guys were there, but that's when I first met Tom and became friends with him. And he pointed out in his speech, he's like, look, if you rely on the federal government, and the federal courts are part of that federal government, to determine the extent of its own power, you shouldn't be surprised if that power grows and grows and grows, no matter which team is in charge, no matter who's in the White House, no matter what the case is, over a long period, that power is going to grow. And that's basically what Jefferson and Madison warned us about in the resolutions of 1798 in Kentucky and Virginia. Going further, I just wanted to point out, because I'm saying, look, it's an opinion, not law. We should look at some of these famous cases and see what they have to say. Even the Supreme Court admits this. So I think, even though the Supreme Court, I'm no fan of the modern Supreme Court, I think everybody on there is just a mess. Even the supposed good guys are a problem as well when it comes to the original meaning, legal meaning of the Constitution. They are pushing for way too much centralized power. The federal government's either going to come and save you or come and ruin you at all times with these guys. And look at here, the transcript of the Marbury versus Madison case, or the opinion in 1803. This is from ourdocuments.gov. You can actually look at the original high-res PDF, and I'll link to this in the show notes at 10thamendmentcenter.com/path-to-liberty. The first line in the original transcript is, Chief Justice John Marshall delivered the opinion of the court. Should I say it again? Chief Justice John Marshall delivered the opinion of the court. And again, like I was saying right at the outset, when someone tells you that they have an opinion on something, I think for most people, it encourages them to think about it differently and maybe form their own opinion. But when they're being told from on high that there's a ruling, or this is settled law now, the Supreme Court made this decision, you should just drop your story on this. This is what I've heard so many times over the years. You have a different view on it. But this is the first line from even Chief Justice John Marshall, the opinion of the court. And this is not some archaic thing that only happened back in the day. It still happens today. And I just happened to grab this particular one. I was going to grab the NFIB versus Sebelius, but McClanahan already wrote about that one. Here's Justice Scalia in the DC versus Heller case in 2008. Justice Scalia delivered the opinion of the court. Doesn't say ruling. It says the opinion, and then they explain their opinion here. And it's very important to note that difference. Now, going back to Dave Benner, he points out that the Constitution delegates very little power to the federal judiciary for a reason. They didn't give them all this power, although they did consider having them have more power, participating in a legislative, basically a review council that Berger covers in some detail in his article and book. But Dave goes on, he says, since British history was rife with treacherous kings who packed the royal courts with those who would innately endorse their aims, the founders embraced the separation of powers doctrine espoused by Charles de Montesquieu for a reason. This is important. They recognize that in their own lived history, their own lived experience, and from the people that they learned from, that someone who held final authority, sovereignty, a king or a queen, an oligarchy, a group of people, when they had courts, even if you had a chance in the court, it would certainly be packed, and we've heard that phrase in more recent years as well, and in modern times, it would be packed with people who had a predisposition to serve that king. And they did not want that type of scenario. So they had a general distrust even of the courts. They didn't see them as this all-powerful, all-infallible group, as so many people do today. They really believe they fall for this. They saw them instead as political appointees, which they still are right now. Going further, one of the chief complaints of the colonists, and I think this is back to McClanahan, one of the chief complaints of the colonists in the years before the American War for Independence, this was a leading concern, was that judges were political appointees. An independent judiciary, then, if we're looking back and understanding the philosophical underpinnings of how this was set up under the Constitution, he says, an independent judiciary was a cornerstone of nearly every state constitution written in the years immediately after the war. And I think we can go back to the Massachusetts Constitution written primarily by John Adams in 1780. The judicial shall never exercise the legislative and executive powers to the end it may be a government of laws and not of men. And again, McClanahan is reaffirming this point that, look, they saw the judges under who they lived, under the empire that they lived, as being political appointees. And politically connected lawyers are certainly going to have politically connected rulings. And that's why we have opinions and a limited, supposedly independent judiciary. And then back to Berger. He says, the founders, it bears repetition, did not share present-day activist enthusiasm for judges. I mean, whether it's libertarians or conservatives or Democrats, depending on the issue, almost every one of these groups of people will cheer on centralization of power under the Supreme Court without thinking of the long-term ramifications. They think only short-term. They are really happy to see the Supreme Court take on decision-making over an issue that was never intended to be in their realm or intended to be a federal issue. And as long as it has a good short-term outcome, they don't think that centralization of power might be used in a bad way in the future, that they might have somebody else in the future say, well, now that we have this precedent, we can go and do the same type of thing on something else. And so many times, Jefferson, for example, and I'm not going to get into all the Jefferson quotes, I cited that last week, Jefferson over and over told us that he was so greatly concerned about consolidation, centralization of power as being the destruction of the republic, the Constitution, federalism, and liberty. And that consolidation he saw as happening already in the 1820s as coming through the judiciary. And the other two branches, the executive and the legislative branch, he saw were going to be the corruption based off of the centralization of power. So the founders did not share this present-day enthusiasm for activist judges. Justice James Wilson, and Wilson, I think, in many ways was really the father of the Constitution, the title that's given to James Madison. Both of them were incredibly influential. Madison flip-flopped a little bit more and I think was a little bit more middle of the road. Wilson was definitely a big government guy of the time. And he said, and if the big government people are like miles different than, or miles better than anybody that we have today, you know there's a serious problem that we're living under. I mean, anyone can look and say, look, we live under the largest government in the history of the world. Obviously, there's a serious problem, but that's a side note. Justice James Wilson, Berger writes, reminded his fellow Americans that they had been objects, the courts, the judges had been objects of aversion and distrust. They were they found them repulsive. They wanted to avoid them. They didn't trust these people. They were politically connected lawyers, and politically connected lawyers aren't on your side. Going to the federal government, a branch of the federal government, to limit the federal government isn't a good strategy. As Tom and Mike Meharry and Nappy and many other people have said over the years, this is like going to your mother-in-law to adjudicate a divorce. I mean, this is absurd. Let's go a little further. This is to Mike Meharry finally, and Mike's done a lot of really good work on this. He says the judiciary has a very specific role to judge cases or controversies. And I'm not going to read the whole thing, but it's Article 3, Section 2, Clause 1 of the Constitution. I'll link to this article, Constitution 101, the Judiciary and Judicial Review. I think he actually included very similar to this text in Constitution Owner's Manual. This is a book that he released that we need to really start carrying here as well, that he released in the last few months earlier this year, talking about this introduction to the judiciary. But it's covered in Article 3, Section 2, Clause 1 of the Constitution. And just briefly, I'll just read the introduction part. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. So you really have to start out with things that are really constitutional. But of course, when everyone thinks that everything is a federal issue, then of course everything is going to be a federal court case too, and that becomes its own problem. The power under Article 3, Section 2, Clause 1 was actually further limited by the 11th Amendment, which I think would make its own good episode at some point as well. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. Going back to Berger, and Berger has so much great work on this, and this was, again, in Government by Judiciary. I think it was 1979 when he wrote this. No one, he says, so far as my search of the several convention records uncovered, no one at the time looked to the court for leadership. And I like how he put that in quotes, because so many people today are like, okay, there's a serious issue that's happening in Indiana or in California, or there's an issue on in the culture war, for example. This is all these things that come up, and there's a court case and they want the Supreme Court, rather than to take an opinion, to share an opinion on whether or not it's a constitutional exercise of power. They want them to have leadership for policy. And this is totally counter to how the founders viewed the federal courts. No one in the conventions in Philadelphia or the state ratifying conventions, and no one from my knowledge has proven this wrong since then. No one looked to the court for leadership in resolving problems that Congress, the president, or the states failed to solve. If they fail to solve, that's a different issue. You just don't want some life-serving, politically connected lawyers imposing their personal political will on everyone forever. And that's a lot of what we have today. And Berger says the court, in other words, was to act as a naysayer, not as an initiator of policy. And we often hear that we need to establish justice, that we have to have justice served by the Supreme Court. They want to enforce their view of justice. So once we start talking about justice, this is kind of a fluid thing. And if this is a just outcome on this or that, but this is, I think Berger puts it much better than I do. For the founders, the unjust was not equivalent to the unconstitutional. Just because something has a bad result doesn't mean that they're not authorized to do it, and vice versa. Just because something has a good result doesn't mean that they are authorized to do it. A good result to you might be a bad result to somebody else. And for focusing, and I've talked about this before, a lot of people substitute the word good for the word constitutional and bad for unconstitutional, rather than what has been delegated to the government in the Constitution. They just impose their own personal political views on what counts as what is authorized. And that's all they care about. And the end result is that everyone who gains the reins of power, the ring of power, all they do is try to impose their personal political view. They don't follow their oath to the Constitution. No one does. Berger goes further. James Wilson, second to only Madison as an architect of the Constitution, flatly declared, quote, that laws may be unjust, even dangerous, and yet not be unconstitutional. So they didn't want a politically connected group of lawyers coming on there and saying, well, this is what we think is good or bad, and then we're going to say that you have to have this. No, they're only supposed to give their opinion on the constitutionality of something that actually qualifies for them to be hearing the case in the first place, the case or controversy as mentioned in Article 3. And Berger also points out this is a view that was likewise expressed by George Mason. Mike Meharry actually points out that if an issue isn't a proper judicial case or controversy, the federal judiciary does not have any jurisdiction. So first of all, it has to fit into that. And I should do an episode to explain what that means on its own, maybe sometime as a follow-up in the near future. If you like that idea, or if you have other ideas, leave a comment in the archives or email me, team@10thamendmentcenter.com. I get a lot of ideas from people sending me stuff or asking questions. Mike points out that the court has no authority to issue advisory opinions or make judgments outside the narrow scope of a given case. During the Philadelphia Convention, Mike writes, Charles Pinckney of South Carolina submitted a proposal to require the Supreme Court to issue advisory opinions at the request of the president or Congress. So here's another proposal, like we got to have them available to give their opinion on this legislation. The convention rejected it. So we know that they considered it, and it's not part of the Constitution. That's not a power that was delegated to them, because they actually thought about it and said, no, we're not going to do this. And Mike points out as well, technically a ruling, an opinion. See, this is an older article. I don't think, 2018. I don't think Meharry uses that term too often anymore, and I've really worked on myself to get it out. It is such a common phrase, and here's a great example. We've made an error. We should go in and edit that. Technically, an opinion only binds the parties to the case, and it can only be applied within context identical to the facts of the controversy. One can certainly draw broader conclusions, but it doesn't automatically apply to all people at all times. And that's, I think, really the great example of legislating from the bench. When the court has an opinion on a specific case, all of a sudden everybody everywhere is applying that exact same conclusion to every similar situation. And he points out that courts tend to follow precedent, and that's probably why. Stare decisis is the idea that precedent rises above the Constitution, even if the Constitution disagrees with that particular precedent. The court, they don't automatically do this, but they more often than not. And Mike says that the courts tend to follow precedent, and future judges won't generally overturn what they see as settled law. But again, it's not law, it's an opinion, even when the precedent strays significantly from the Constitution as ratified. And I did a very short video, it's like a 3-minute video on this last November, stare decisis, precedent versus the Constitution. And I just hope you'll check it out. Again, I'm linking to this in the show notes. We're going to actually post it a little bit later today, this evening, on our Twitter and Facebook pages, maybe some other social channels. But here's a quick summary. As the founders widely understood, the Constitution is supreme. It says it in that so-called supremacy clause. The Constitution is supreme, not the opinions of the courts. And it remains supreme even if the opinion of the Supreme Court contradicts it. There we go. Opinion. Got that right. Not something to fix there. I hope you'll check that one out as well. And back to Dave Benner before summing this up and closing out. He says, when the courts act to create de facto law rather than by rendering of opinion, they violate the intentional separation of powers doctrine used to diffuse powers not only between separate branches of the general government. I like that he uses the term general government, which is what the founders all use. They didn't call it the federal government. I mean, maybe in some situations it was generally called the general government because it handled general purposes, and the specific detail, everything else, was left with the people and the several states. He says it not only violates the intentional separation of powers between the separate branches of the general government, but also the paradigm of the general government and the states. And Dave has a great line here. When a group of 9 judges attempt to make law for a populace of 310 million and settle constitutional questions for all time, they are acting against the interests of the compact of the Constitution. Such a situation is demonstrative of an oligarchy, not a republic. And when I read through that again, I'm like, oh, okay, of course. Benner would call it an oligarchy because he's a Jeffersonian, and he knows that Jefferson warned us of an oligarchy. Here in a letter, this is in 1820, September 28th, 1820, to William Charles Jarvis. And he put it this way: you seem to consider the judges as the ultimate arbiters of all constitutional questions. A very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. Well, I hope you guys found this interesting. I hope you found it educational. Man, I hope you learned something. That's the most important. And again, as I mentioned right at the outset, we're celebrating our 14-year anniversary on the 26th, June 26th. That's Friday. So all this week and next, and maybe a little bit after Independence Day, we're going to be sending out a bunch of emails and highlighting some of the most important articles and issues that we've covered on this site. On Monday, I did an episode announcing the release of our State of the Nullification Movement report. Today, we're talking about the Supreme Court and its issuing of law for so many years and how it's a serious, serious problem, and the warnings against this, how the founders actually had a different view. On Friday, I think I'm going to go through just for Fast Friday, I think I'm probably going to go through a list of things that I've learned over the years running this organization and working with people from all across the political spectrum. I think that will be pretty cool. If you like the show, if you support us, I'm going to look at the live chat and the questions and comments a little bit later. I don't get a chance to reply to all of them, but I do read them all. So please do continue leaving comments, whether they're live or in the archive. I appreciate it so, so much. And if you support the show and you want to take a couple of free, easy actions and help us spread the word, all of the platforms you watch or listen on are very easily triggered. So just simple actions will trigger the algorithm and tell it to show the program to more people. Smashing the like button, leaving a review on iTunes, subscribing, getting notifications, comments, sharing links, etc., etc. All that stuff helps us spread the word and reach more people, as we've been doing every single month for the last 2 years that this show has been running. And if you really want to pitch in, our anniversary week is the absolute best time. I don't want you to feel pressured or obligated to do so, but if you do have the financial means to help us out, I would be extremely grateful for any consideration you can give to joining us as a member today. It starts out as little as $2 a month. 10thamendmentcenter.com/members is the place. And for those of you who are already members and have been asking me, oh, hey, Bolden, where can I do just a one-time donation or whatever? I'm already a member. That's 10thamendmentcenter.com/donate. All right, enough of the promotional garbage. I really, really appreciate you being here. I appreciate you spending some time with me. I appreciate your support, whether free, financial, or anywhere in between. Again, I hope you learned something, and I'll see you next time here on the Path to Liberty on Friday. Thanks so much for being here, and have a great day.